Another interesting case came about through the Life Insurance Corporation of India versus Manubhai Shah. This was decided in the year 1992 by the Supreme Court of India, which involves a very interesting issue of publication by the Life Insurance Corporation of India. Now, Manubhai Shah was a consumer activist. He was somebody who was championing the cause of consumer protection, and he was trying to bring about a sense of accountability from different agencies that were giving consumer services, among them the Life Insurance Corporation of India. LIC in fact had a magazine, and it would actually publish this magazine, and while publishing this magazine, they would actually bring about a lot of aspects about how LIC is coming up with plans, schemes, policies, how many customers it had, so on and so forth. And this was like a newsletter, this was like a publication magazine that would be circulated among various stakeholders who had subscribed to the Life Insurance Corporation of India. Now, interestingly, Manubhai Shah was critical about Life Insurance Corporation of India and its policies, and hence he actually wanted his critique to also be published by the Life Insurance Corporation of India. Now, obviously, LIC took a position saying that this was their platform, and hence only those that are necessary for promotion of LIC schemes have a place for publication. So Manubhai Shah felt that this was not correct, because LIC, while in its publication, was using public funds and public money, because LIC is a public sector undertaking. So it's a taxpayers' money that was finally being reflected in how LIC was going about its function. And hence, being a public institution, it was expected that it must play very fairly, and its platform should not be only used for its propaganda material, for its publicity and marketing material, but also for any critical view that citizens may have about the functioning of LIC. Because every public institution must be amenable to public view, it must be amenable to public scrutiny, and it must be amenable to fair criticism by its users. And that is probably a mechanism for feedback, where public institutions can only improve their services towards the citizens and towards the consumer. So unless institutions that are providing services are open to hearing views, critique or feedback from its citizens, I don't think the institutions that are providing services will actually improve their services. And hence, in this very interesting case of LIC versus Manubhai Shah, the Supreme Court accepts the petition of Manubhai Shah. They see that this is a very important game changer that public sector undertakings will have to adhere to, and hence they said that the magazine that was published by LIC must also publish rejoinders if there are any. So it's like saying that if somebody has expressed a view, somebody can express a contrary view as well. And I think that is exactly where the Manubhai Shah case becomes a very important case in the freedom of expression development in India, because what it said is, if one way of communication can be expressed, the other way of communication can also be expressed. So this is like, defense and counter defense. This is like argument and counter argument. I think every kind of expression, it need not be always be an expression that favors the government. It need not be an expression that favors the agency. I think counter views and expression, and which we in popular democracy call dissent, must have a space, must have a platform, must be taken equally seriously. Now, this is important because then, by looking at defense and counter defense, people can make their own choice. People can make their own selections about which is right and which is wrong. And I think, in a democracy, it's not one view or one expression that should find means of publication. I think every view must be able to be communicated, and I think that is where the free speech or free expression finally finds its attainment of goal, attainment of human expression is finally achieved by all these purposes. So I think the freedom to circulate one's view is part of freedom of speech and expression. So if I wish to circulate it, I can circulate it either through leaflets, pamphlets, either through my own blog or through my own magazine. However, when public magazines are being published, I think they should give space to all kinds of views. And hence, I think both the majority view or the minority view needs that equal amount of freedom and expression as well. The court said that in recognizing such a kind of right, the right to express dissent, the right to express a different view, the right to criticize, fair criticism. Kindly note, it should not a right to criticize in terms of defamation, but the right to fairly criticize is something that the government must facilitate upon, and hence any kind of discretion in this is to be absolutely rejected. So all public platforms, all public publication or government publication that are using public money must provide expression for both aspects, positive as well as negative. And I think this is where the real free speech and expression gets protection, recognition under Article 19(1)(a) of the Constitution of India. The last paragraph on this case is about the contention of the state. It was rejected by the court because the court said that, look, you are using public function, you are using public money, and hence anything that you do in public money and public function should be in public interest. And public interest can only be served if all views are taken on board, and the same provides equal expression as well. Interestingly, just to add a development to here, we are talking of press freedom, press which is organized press. It could be like Bennett Coleman, it could be like Indian Express, it could be NDTV, it could be any other online media. But I think press also includes publication, which can be those kinds of publication that are government sponsored, those kinds of publication that are government patronaged. And I think press means anything that is communicated as information which reaches a section of a community. It can be a section of community in the Indian Railways where there is a newsletter. It's a section of community protecting minority interests. It's a section of community protecting labor interests. It's a section of community that is protecting consumer interests. So I think these are all within the domain of the press. I think press is not only restricted to national newspapers and national news television. I think press is all about where this communication can take place and what is the basis for the same communication. What is important and pertinent to note at this point of time is a very interesting policy that was published by the Lok Sabha Secretariat in the year 1985. In 1985, they published a document which said something like this: background to evolving a national information policy, which very clearly meant that the Lok Sabha Secretariat did understand, appreciate and acknowledge the role of the press in our democracy. And they said that it is important that the press be involved in the national politics, in national elections, in national policy making. And hence it is pertinent and important for the parliament to actually publish its methodology, processes and its functions through the press media. And hence it is important for a communication policy to be developed, which they call the National Information Policy, wherein the Secretariat would then probably lay down the way, method in which the Lok Sabha functions could be brought about through the press. And that is an interesting development that happened in the year 1985. National Information Policy. That is what the Lok Sabha Secretariat actually published. Right. Let's go forward. And in going forward, the next case for discussion or the next kind of intervention that the court did, the Supreme Court of India did, was through the Indian newspapers case versus Union of India, a case decided in the year 1986. Now, one would appreciate and note that the government of that day, unlike the Bennett Coleman case that was decided in 1972, in 1986 the government decided to have an import duty on a newspaper. So, naturally it's the government's discretion prerogative to bring about a regime of taxation, and they can actually decide to change tax policies as they wish. They can do so by laying it down in the parliament and getting it enacted in the parliament. However, in this case, when import duty on newspaper was decided by the government, Indian newspaper, they went to the court stating that if import duty is fixed, it would actually increase the cost of communication of newspapers. What would that do? It will provide a disincentive for citizens to actually buy the newspaper, because it will be that much more expensive than what it was before. So import duty does contribute to the cost of production of the newspaper itself. Now, increased cost, does it have an impact on curtailing the freedom of speech and expression? This was a question posed to the Supreme Court of India. Now, the Supreme Court in this case did consider the fact, the role of the government. Why was the import duty done? Was it something in public interest? Should it be something that the court should permit? Would it have crippling effect on freedom of speech and expression? Will it affect the guarantee of rights? And should there be some kind of intervention on the taxation policy of the government? These were a few things that the court was asked to intervene upon in this particular case. Now, the court in this case highlights the role of the press. They actually reiterate, I must say, this was not the first time that Supreme Court did so, but I think they found a great opportunity to impress on the government the role of the fourth estate, the role of the watchdog called the press, the role of the press in bringing accountability and transparency in government. I think by this time, probably the Watergate scandal and so many other scandals in different other countries had actually brought to the forefront the role that the media can bring in, the role that the media can do. And it was actually becoming quite a powerful institution in itself. And hence, the court says that the freedom of expression has probably four broad social purposes. Okay. First of all, what does the freedom of expression do? It helps an individual attain self-fulfillment, right? So through expression, I try to become the human being that I wish to be, and I can express myself as a full human being. So that is what a freedom of expression does. Second, it assists in the discovery of truth. Now, this is very important. What the press will do, or probably is expected to do, is to give you information that is authentic, that is something reliable, that is truth, but nothing else. And I think what it helps us to do is to find out what is the fact as against what is the myth. And I think this is very critical and important, and the press assists us in doing the same, and the freedom of expression actually brings out the best in the human being. Third, it strengthens the capacity of an individual in participating in decision making. Because see, when the press reports something, I either want to vote for it or vote against it. I want to be in favor or be against it. I think it is important for individuals to take positions. It is important for individuals to express their satisfaction or dissatisfaction on a particular matter. And participatory decision making, which is the foundation of any democracy, where people are involved in every decision making process, can only be strengthened if we strengthen the fourth estate, that is the press. The court went ahead to also say that if we are looking at social change and we are looking at stability, I think the press has a very important role to play. Friends, I cannot reiterate enough, and probably there are no enough words that can insist on the role of the media in bringing about social change or social reform. The media, I think, has gone about in bringing about change in so many aspects of our day-to-day life. For example, overruling untouchability. Right? The media has played a very important role. It is about education, it is about communication, it is about changing our methodology, our way and manner in which we treat the untouchables. I think in eradicating untouchability, the media has played a very significant and an important part. If today we have eradicated child marriage in India, to some extent, and I believe almost absolutely, I think the media has played an important role. While we say that the law brings about social transformation, please note the communication of the law, the knowledge of the law. I think the reach of the law can only be enhanced through the press and the media. Recently, if you look at the position of triple talaq, I think the social change that was attempted was also something that was championed by the media. And hence, while social change is relevant and the role of the media is important in bringing social change, one cannot forget the fact that you need proper reporting, you need proper information, and that kind of a social change can only see the light of the day if it is brought through some kind of stability. Right? You don't expect social change to bring about instability in the legal system. So social change is necessity. It is something that every generation aspires for. I don't think any law or any legal system is going to be static. It has to be dynamic. Changes are expected, but it should be done in a manner that does not bring about instability in the society. I think media plays that critical role. Freedom of expression through media plays those critical role, and it helps us achieve the four broad social purposes is what the court had to say in this case, called Indian Express newspaper versus Union of India, as it was decided in the year 1986. Friends, it would be important to also note that when I talk about the right to know, the right to know also has what I call as right to access this information, the right to receive that information, and the right to be able to form your own belief in that information, and the right to communicate the information. I think these are all aspects that are covered under the right to know. So let's sum it up in this sense, and this is something to take the observation of the court ahead. What does freedom of expression have? Freedom of expression has one. Do I have the right to acquire information? Yes. Do I have the right to access the source of information? Yes. Do I have the right to communicate my information? Also, yes. I think in all these three, there is an affirmative answer to the way in which I understand freedom of expression as enshrined in Article 19(1)(a) of the Constitution of India. And hence, if we have to learn from the couple of cases that are relevant and important at this stage, I think what it probably gives you is that the freedom of speech serves to protect two kinds of interests. Okay, first, it tries to protect individual interests. That is about an individual citizen, a consumer, an individual who probably wants to access that freedom of speech and expression. It is very important for us to, as a human being, to have this kind of right. And please note, we always say that freedom of speech and expression is an inherent human right. It's an inalienable human right. It's something that cannot be transferred, assigned, or granted to any individual, right? And second, I think it's about a community right, because we as human beings have always lived in a society. We don't live alone, and hence it is a group activity that also needs a certain degree of protection. And that community or group activities protection of rights comes through the freedom of press, is what the Supreme Court wanted this nation to believe in and to take it forward. I think press in India is a reflection of our society, it's a reflection of our individual aspirations, and it's a reflection of what we stand as a nation for. That is what the freedom of speech and expression in terms of individual and community right and interest goes forward too. Interestingly, the right to know, as we think is not restricted only to those who are enjoying their liberties or those who are part of the free society. If you look at the couple of cases that we had come across vis-a-vis what the Supreme Court wanted us to look into, I think free speech and expression was something that the court said is not only available to free citizens, but it is also available to prisoners, right? And prisoners also have certain rights, isn't it? Now, in Prabhat Dutt versus Union of India, a case decided in the year 1982, the media wanted to interview two prisoners who were actually on the death row. These were two notorious gangsters called Ranga and Villa. They were quite popular at that point of time. They had committed numerous crimes, and they were actually sentenced to death, right? Excuse me. Now, the interesting facet is, we are quite inquisitive as human beings. We are inquisitive not only in our lives, but in lives of other human beings. We are inquisitive to know how did ordinary people turn as convicts. How did ordinary people turn as criminals, right? Now, why is this information relevant? If you ask me, this information is relevant because probably we can stop others from being criminals. So it is important here to understand and realize that it is a study of why the crime took place and what made these criminals do the same crime. So I think that kind of a study is only relevant, and it is important for the media to highlight the same so that there is larger education among the community about what is the consequences of a crime. What will happen finally of a crime, and how did ordinary individuals actually turn into criminals? I think this is a great information to have. However, the media in this case was denied the permission by the jail authorities to interview the prisoners. They said, look, you can interview under trials, you can interview those who have committed the minor offences, but not these two, Ranga and Billa, because they are prisoners who have been given death sentence. So they were dangerous, and probably they had done certain crimes in connivance with very powerful people, or they did the crime for powerful people. And hence I think the jail officials did not allow media into the prison and to undertake the interview. However, the Supreme Court again reiterated the fact that the media has a role to play, and the media cannot be gagged, the media cannot be stopped from interviewing the prisoners. The only thing is they have to follow the prison manual, they have to seek permission, and probably the interview will have to be recorded, and probably it has to be something that the jail authorities can view, and based on that, I think the media's freedom to interview the prisoners cannot be curtailed, is what the Prabha Dutt versus Union of India case did say. Which means if the prisoner, if an under trial or a convict wants to publish his own story about how he did the crime, why did he become a criminal, so on and so forth, I think they have a story to tell, and it's a story that is quite fascinating at times for all of us to read and understand, because I think crime stories are quite imaginative, they are quite captive, and I think they make big movies as well. I think there are a lot of books that are written, there are biographies that are written by criminals, and I think that is something that citizens have the right to know, is what was decided in this case called Prabha Dutt versus Union of India. I also at this point of time remember a very interesting case called the Auto Shankar case. This is the case called R. Rajgopal versus State of Tamil Nadu. This was a rowdy by name Auto Shankar. He had actually committed a lot of murders, and he was also sentenced to death. Now Auto Shankar wanted to write a biography, and he hired a pressman, Nakiran, to write a biography for him. And he wanted to write this biography in the prison, obviously. So before he could be hanged, probably he wanted to tell the world, why did he do and what he did for. Now at this point of time, the state of Tamil Nadu decided that Auto Shankar cannot do the same, right? And they insisted that he should not write it, and there must be an injunction against the publication of his biography. Now, why did the state of Tamil Nadu do? I think there was a suspicion in Tamil Nadu saying that Auto Shankar will disclose the names of prominent politicians in his book and prominent police officers who helped him do the crime. And the politicians and the policemen felt that they will be defamed in the book, right? And hence they wanted that book not to be released. But again, in this case, I think what the court said is, I think every accused has a right to express. I think, if you look at death row, I think you have the right to make the last wish, right, before you are hanged. And in this case, I think expression of views by a person in a death row is not something that can be prohibited. I think media has every right to express the same. However, please note, the media also takes the worth of being sued for defamation if it's not true. So what the media has to do is to protect its own interest by reporting only truth, facts, and not stories that may unfortunately either infringe the privacy of individuals or defame individuals as well. So I think the media will have to be very, very careful when they exercise their freedom. And please note, every freedom under Article 19 comes with restrictions under Article 19 too. And one of the most important restrictions that is laid down in Article 19.2 is the following. First, public order. You cannot, by your own publication, damage or disturb public order. Second, you cannot, from your publication, defame any individual. So defamation is a great restriction on the freedom of the press. And hence, while information is being shared, defamation is to be avoided as well. So the R. Rajagopal was a state of Tamil Nadu case, I think, is another great addition in understanding the rights of accused to free speech and expression through the instrument of media. I think that is what we say The right to know, and please note, ordinary individuals cannot go to the prison. They cannot interview prisoners. The media can do it. They can use their power of communication to put the story across to the whole world, and they can communicate it to the whole world, including those that are interested to know about it. I think when you talk about civil liberties and the rights of the accused, please note, we say that an accused has the right to information, and this is protected by the Constitution in Article 22. An accused has the right to be informed about the grounds of his arrest. An accused has the right to be produced before a magistrate within 24 hours. An accused has the right to be informed that he can be represented by a lawyer. These are basic information that an accused has. Now, please note, this is what is right to information. So when I have been curtailed of my liberties, when I have been curtailed about my freedoms, I must be told why it is being done so. And probably I must also be told how I can actually get back my liberty and freedom. I think right to legal aid, right to legal aid information, or right to be informed why my liberties is being curtailed in a democracy, I think is a fundamental right and something that adds to the freedom of information legal regime. And hence in Gopalan versus State of Madras, the Supreme Court says that every accused should have access to his arrest information. So I think whether what you have done is a bailable offense or non-bailable offense, whether this requires a warrant or not a warrant, and I think if you are not in a good physical condition, you have the right to be examined by a doctor, and in case you require medical help, I think you have the right to be sent to a medical aid. And I think these are basic information that have to be shared with the accused. What is relevant and important here is, friends, please note, the family or the relatives also have the right to information. So it's not only the accused. What does the family have the right to information? The family has the right to be told where you have been kept or detained, the place. So if they wish to visit you, if they wish to apply for bail, if they wish to pursue your matter and to prove your innocence, I think the required information that the family has or should have is something that the family has the right to information. So I think here, by these three cases, one gets a view and an idea about how far and to what extent family can access that kind of information in case of prisoners, in case of those who are being detained and whose civil liberties have been curtailed by the state. The state has a duty and an obligation to disclose the said information to these citizens. So I think this is the kind of legal development that we are looking forward to in the right to information age. I think police, the state through its agencies like the police, have the duty to inform, and that duty to inform clearly is a duty on right to know. And I think that is an important aspect about understanding the right to information legal regime prior to the statutory law of 2005, in which RTI was enacted as a basic law. Kindly note, Right to Information Act 2005 applies to the police department. It applies to prison authorities. It applies to the state prosecuting agencies as well. So apart from the constitutional obligation, as we see in these three cases, apart from the obligations that the Supreme Court has laid down by guidelines from time to time, under the RTA Act of 2005, now there is a statutory obligation, there is a process and the mechanism in which these three agencies, the police, the prison authorities, the prosecution department, may have to share with the citizens as well. Plenty of cases where we see judicial activism, where we see the courts trying to protect, ensure the rights of citizens. Another case in the addition is the Printers Limited versus CTO, where the Supreme Court reiterates that freedom of press is not expressly granted, however, is very much implicitly granted for free speech and expression. The court in this case says that the fourth chamber of democracy is the press, and the press have the right to know. It's a collective right. It's an important right that the press must enjoy, and it's a fundamental principle of a democracy to grant this to the press. And free flow of information and participation of the people in the administration is something that is very, very crucial for democratic institutions to survive and for the aspiration of the people to be projected. So it is a primary duty of national courts, this is what the court says, to uphold this freedom. And hence the courts have to check and balance administrative institutions that violate this kind of a freedom. It is the duty of the court to look at whether the laws curtail freedom or whether administrative actions interfere with the freedoms of the constitutional body. So the courts on themselves took about the task about regulating the two other institutions, the legislature and the executive, in case they went about infringing the right to know, and hence they said it is our duty to protect the right to know, it is our duty to protect the freedom of the press, it is our duty to protect democratic principles in the country. So in Printers Limited versus CTO, the Supreme Court says it is the duty of all the national courts to uphold the required freedoms, and it is something that the Constitution has mandated the judiciary to do. And hence you will notice that whenever the state action or whenever any law, be it the newsprint control order, be it the import duty, if there was a law that actually infringed the freedom of speech and expression, I think the institutions that felt that they were aggrieved went to the court. Wherever individuals fought that their right was being infringed, again they went to the court, and it was the court that protected their right. It was the court that adjudicated the matter. And hence, if I look at the legal development in India on the right to know, I think the right to know was expressed by the court, it was defined by the court, and it was protected by the court till we got the Right to Information Act in 2005. So the role of the court, the role of the judiciary has been very crucial till the time the statutory enactment of 2005 was made. And the court, I think, performed extremely well, exceptionally well in trying to protect this kind of a individual as well as community right on right to information. And I think that is where the growth of this law, I think the transparency rule, the accountability rule slowly started coming to the forefront in this country. I think we have discussed this case previously as well, but the Ministry of Information and Broadcasting versus Cricket Association of Bengal also is another addition to the constitutional history. It is another addition in terms of what kind of information a person is entitled to read and what should be brought and what should not be brought about it. The reader's right to access the newspaper was his right to information, and I think it is important that everybody gets information about, say, what is happening with the sports event. I think this kind of news or information is very critical. As I told you in the past, we all have our own requirement of information. Some of us may need information about newer forms of cooking, newer dishes to be made. Some of us may need information about what our interest is. I may be interested in sports, I may be interested in business, I may be interested in stock exchange, I may be interested in lending, I may be interested in international trade, I may be interested in some. So I think while human beings have varied interest of their requirement, I think it's the press that feeds this information, right? It is the duty of the press to give the different kind of information that may be consumed by citizens, and hence it is in the reader's interest, it is in the citizen's interest, or it is in the consumer's interest, as the case may be, to access this information. And the only means of accessing this information before the social or digital media came in, before media started giving this information through the internet, I think the only mechanism, authentic way of getting that information was through newspapers. And I think what this case again reiterates is the role of the media through newspapers in reaching out this information to the communities and to the citizens. And hence, sports related information is also an information that we are entitled to, and the same should be given unbiased, without any discrimination, and without any preferences between the private media and the public media. Let's now come to the real focus of, say, the right to know domain. The right to know domain firmly fits into this case of 1975. The case is State of UP versus Raj Narayan. Probably a very popular case in terms of constitutional history, popular case in terms of government functioning, popular case in terms of how the government of the day is accountable for its decision-making processes. I think in 1975, when the situation in India was quite volatile, and when Raj Narayan asked a few relevant but pertinent questions, the state actually denied it. Because at this point of time, I think the kind of attitude that the state had, especially in 1975, where it was almost a single party system, where the opposition was very weak in the legislature, the administrative bureaucracy in the government literally took upon itself only being a government servant and not a public servant. These were the times when the Supreme Court had to take up this case of state of versus Raj Narayan. And I think at this point of time, you will notice that the judiciary was slowly waking up to the reality that it had an onerous responsibility in ensuring social, economic, and political justice. The judiciary had to probably intervene in certain matters. So the time was right for the judiciary to start asserting itself. The time was right for the judiciary to implement the spirit of the constitution, as it were. And hence, they got an opportunity in this case of 1975. Now, what did Raj Narayan ask? He wanted the government to disclose two things. First, the security guidelines for the Prime Minister of this country. And second, I think most important and prominent, he was concerned about the expenses involved in the Prime Minister's travel. Right? So, security is one concern, and the expenses were the second concern that Raj Narayan wanted to know. So, he said, why don't you disclose this? Right? Now, the Prime Minister is the chief, chief officer of the government. He is not only part of the legislature, he is also part of the executive system. And the Prime Minister makes law. He also is probably implementing the law through the cabinet and through his government. And the Prime Minister's office is a very powerful office. And probably when the Prime Minister travels, they use public money. And probably the only question that I would want to ask here is, can the expenses of the Prime Minister travel be disclosed under your right to know? Should it be disclosed under your right to know? See, interestingly, many of these security guidelines or expenses in the Prime Minister's office are not published, right? So there are many documents, there are many information that generally don't get published. They are all kept but never published. Now, publication is an official way or manner in which the government communicates. Now, how are these communications of publication done? They're done through what is known as an annual report of a particular department or a particular ministry, or they are published in the form of some memos, circulars, and so on and so forth. However, many of what the government does is never published, and hence it's never available to the citizens at all. Now, when a public functionary involves public money, shouldn't there be a sense of accountability? Shouldn't there be a sense of disclosure? Is what the court had to evaluate in the state of UP versus Raj Narayan. And I think what Justice K.K. Mathew, in his dissenting opinion, said was very, very relevant. He said, look, in a democracy like ours, in the interest of the public, the veil of secrecy has to be removed. If it's state security, one can understand the veil of security. But if it's common routine business of, say, the Prime Minister's travel, what is the secrecy that the government wants to justify? Why should the government withhold this information? I think what Justice K.K. Mathew in this case said was, if you decide to have a veil of secrecy, it will only breed contempt. It will only breed corruption. And hence, contempt and corruption only will breed oppression. And hence, it is very important for the agents of the public. Now, who are the agents of the public? It is the government officials. They represent people. They don't represent the government. The government is only an employer. So when you are an agent of the public, it is your responsibility. It is your conduct in public interest, which should say that we should have only few secrets and we should try and disclose certain relevant information that the public ought to know, on which the public have the right to information. I think what is important over here is that, the Supreme Court said that in democracy, transparency should be the rule and secrecy should be the exception, right? Not that you cannot have secrecy. You ought to have secrecy in terms of national security and national interest. I think if you look at Section 8(1)(a) of the Right to Information Act 2005, even the law that currently stands does provide exemption for information of national security and national interest. However, that is an exception, right? That is something that you can exercise if it is necessary to do the same. However, the rule is disclosure, the rule is transparency, the rule is sharing of information. And hence, I don't think the government understood the implications of this case. I think the implication of this case were very, very huge. It had an impact of a international character, because the Supreme Court, as early as in 1975, did say what should a democracy stand for, what should a government stand for. I think a democracy government should stand for disclosure, for transparency, and secrecy should be an exceptional principle that the government must follow upon. The next case for discussion is the S.P. Gupta versus Union of India case, a case decided in 1982. This is popularly known as the Judges Transfer case. And at this point, I think the petitioner, he did not want information from the legislature. He did not want information from the executive. He wanted information from the judiciary. Now, we say the legislature, executive, and the judiciary are three organs of the government. And if I want to implement the transparency rule, I think it has to be equally applied to all the three organs of the government. Now, in this case, generally you would notice that, appointments are generally made by the government or the executive wing of the government. But the judiciary, in cases like the S.P. Gupta case, decided that appointment of judges or transfer of judges should be done by the judiciary itself, so that it can protect autonomy of the institution and it can protect independentness of the institution. So political interference in appointment and transfers can be taken out, is what the judges thought, and that's the reason they passed judgments wherein they took on themselves the appointment and transfer processes. And this was probably quite a landmark decision on judges' appointment that happened in this country. However, what is the process and mechanism for transfer of judges? Are there rules? Are there regulations? And are they adhered to? Second, how are the appointment of judges happening? What is the process? What is the mechanism in which judges are being appointed? I think the S.P. Gupta case very clearly said that the government had an obligation to disclose the same. It is not the discretion. It is not an arbitrary decision that the government can take. And the central government said that appointments and transfers are secret information. This need not be given, is something that the court rejected. And the court said that the government of the day must be fair and transparent. They must provide reasons for transfer. They must provide the process of selections and appointment. And there must be a sense of accountability about who is appointed as a judge and why is he transferred from one place to another. I think these are certain necessary functions that the government must perform. And please note, unless the government is open, unless the government is disclosing the reasons, I think the institution of the judiciary may be adversely affected. The autonomy of the institution may be adversely affected, and the judiciary may lose the credibility and the faith that the citizens have in that kind of an institution. This is something that the court said that the government of the day had a duty. And if it violated that duty, the judiciary thought it is best to take away this function from the government, and the judiciary took upon itself the role of appointing and transferring judges. So the S.P. Gupta case was a Union of India case, again reiterates the fact that judicial related information must be disclosed and must be in the open form. It's the duty of the court to actually put this into the public domain.